We're on the record in People versus Michael Marvin, file number 245339.
Here, Coke on behalf of the people.
Jim Sherman on behalf of the defendant, Michael Marvin.
So we're set for a couple matters in this case today. We have a motion hearing set, and then this is also the final status conference with a trial date set for May 12th. Mr. Sherman, I did get your motion. I had a chance to review that. And Ms. Coke, I also had a chance to review your response. So, Mr. Sherman, anything you wanted to present today by way of oral argument?
Your Honor, I would waive oral an opening if Your Honor has reviewed the motion.
Okay. Ms. Coke, anything that you wanted to present today?
Yeah, I would just state that, as I stated in my response, I don't believe there's any legal arguments whatsoever to suppress any of this. There is a search warrant. I've attached all the exhibits, and I think they support the arguments I made in my response. I'd ask the court to deny the defendant's motion, and we have prepared a blank order for whatever the court decides and attach it to our response. Thank you.
All right. I guess, Mr. Sherman, my question to you is, because what seems to me we have here, at least from your what's written in your brief, is a dispute over factual dispute over what Mr. Marvin's condition was when he arrived, his performance on the field sobriety test. Your brief alleges that he satisfactorily performed all the tests. Ms. Coke's brief alleges that he that there were 6 out of 6 clues that the officers found, including the case next to Agnes. So if we have a factual dispute here, I think what I would need to do is set this for an evidentiary hearing. So is that your position? I mean, are you disputing Coke's factual assertions of the information that's in the officer wrote in your report?
Your Honor, yeah, I was hoping the court would set this matter for an evidentiary hearing, so the court could hear testimony from the officers that were there at the incident on July 3rd, 2024, and that there is a factual dispute, but not as to the condition that my client was in at that time. The factual dispute is whether the officers had probable cause to arrest my client under the totality of the circumstances.
Okay. Ms. Coke, do you have any objection to an evidentiary hearing?
No, and frankly, I was going to subpoena the officer to attend today, but I saw the docket and realized there was not time to do testimony, so I did not do that. And he's running the junior deputy program, so he couldn't come anyway today. But if the court wants to set it, we can do that. We ran the preliminary examination. Detective Copadlo and Deputy Taylor have already testified. That was done on 10/22 in front of Judge Burmeister. So we can either review that transcript or we can set it for a hearing.
All right. I think what needs to happen is I do think there needs to be an evidentiary hearing. Mr. Sherman, just to kind of, I don't believe you practiced in my court before. In these kind of cases, it's not something that I set for an evidentiary hearing. It would be something that you would, so like when you noticed up this motion, you were anticipating wanting to take evidence, you would have set this for like an hour hearing instead of just noticing it up. So I'm going to ask that you do that. Contact my office, ask for a date for an evidentiary hearing on the motion, indicate to my assistant that we're going to need 1 hour for that hearing. I think that'll be enough. Ms. Coke, you believe that would be enough time?
I do. I'm just concerned if we're going to be able to get it in within the next 2 weeks. We can also email Jen and let her know that this is happening so she starts looking.
Yeah. Mr. Sherman, would you have any objection to having that hearing by Zoom as opposed to in person?
I guess I would be hesitant, but if that's the only way we can fit it in before the trial on this matter, that would be fine.
All right, so let my assistant know and call for the date that we want to try and do it in person.
Okay, thank you, Your Honor.
All right, and then the court will leave the trial date on for May 12th, and then we'll get that hearing scheduled prior to that. Mr. Sherman, anything else I can address for your side today?
Nothing further, Your Honor. Thank you.
Ms. Coe?
No, thank you.
Thank you. That's all for today. All right, ma'am, is your name Michelle Danko?
Yeah.
Are you able to hear me okay?
Yep.
All right. We'll go on the record in People versus Michelle Danko, file number 255398. Again, counsel, put your appearances on in that case.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Michelle Danko.
Set for a status conference today. I believe this is Ms. Danko's first appearance before circuit court on this file. Mr. Thompson, can you tell me what things are at your side?
Your Honor, we've had some pretty extensive plea negotiations. At this point, though, I've been advised Ms. Danko was arrested only on Saturday. I haven't had a chance to speak to her. I just found out today and haven't been able to make contact with Genesee County Jail. So I would ask for a new hearing so I could try to determine what is happening with her at Genesee County and how that might interact with our case.
So do you have any objection to that?
I do not. At the next hearing, we will, our offer, which is to an attempt conspiracy, will be withdrawn. That offer was made in January, but I understand that she's lodged and that's not something defense counsel can foresee. So we'll just, we don't object to the adjournment.
Okay. Ms. Danko, were you able to hear all of that?
Yeah. Is that a no jail time offer or?
Your Honor, there is no Killebrew or Cobb's associated with that. So it's generally not accepted in this court, but either way, there's none with that. And it's likely to have some jail based on her guidelines and her criminal history.
All right, so Ms. Danko, the answer to your question is no, there's no agreement regarding any potential jail time.
Okay. I guess whatever my lawyer suggests.
Well, what he wants to do is adjourn this today so that he has a chance to talk to you about your new charges there and how that might interact with your case here.
Okay. It shouldn't interact. I mean, these charges should get dropped. Is my understanding.
You have an objection to giving your lawyer a chance to talk to you about that before we proceed further on this case?
No.
Right, so the court will set this for another hearing. Mr. Thompson, if you could just communicate with Ms. Pope about Ms. Danko's status there in Genesee in terms of whether we can direct her to that next hearing.
Yes, I will keep the court updated.
All right, Ms. Danko, your attorney, Mr. Thompson, is going to be in touch with you, okay?
Okay.
That's all we have for today, and the court's going to disconnect at this time. People versus law, case number 255382. Versus Mr. McLaws, district court file.
Sierra Coke on behalf of the people.
And we're on behalf of Mr. Law, who's present, standing to my right.
Okay, so we're set today for two matters, felony file and then a sentencing on probation violation, district court file. Felony file, can you tell me where that stands at this time?
So I've had a conversation with my client. We are discussing the plea offer. We would ask for an additional, at your next available court date, another 7 to 10 days, just to review that and go over that and make sure that he's confident in what the expectations are, and what the penalties are likely to be.
Just so that both, I guess, this code, so that you're aware of this as well. I will not have early May motion day here. The court has a social conference that all the judges are required to attend, so. In the mid-May, day is full, so if we adjourn today, it's gonna be June before we're able to proceed, June 5th.
So just so we're clear, the recommendation on the probation violation is 30 days. Would the court be granting him credit on those 30 days against any plea or sentence that's imposed in the felony matter? In the
I
petty
believe
matter?
he would be entitled to credit because his bond was revoked. Felony case, so
We would have
he
no
will be
objection to the-
accruing credit, yeah, felony file. I believe.
And we would have no objection to the adjournment. Out that far.
If he's serving, once he's sentenced, he is gonna get credit, but my understanding is once he's sentenced, then he no longer will get credit on the felony file, if I'm understanding how they do the credit correctly.
On the
So
probation violation?
once he's under sentence in another file, I don't think he gets credit, even if his bond is revoked in this
Is that
file.
right?
That's the way I
Yeah.
understand it.
Any sentence.
Okay. Okay, so then he would not get credit on the felony file for the time that he's under sentence in the district court probation violation.
Would he get credit if we adjourned out the probation violation sentencing?
Yes.
Yeah,
We would ask the court to do that.
all right, Ms. Coke. Well,
Yes, sorry,
Katie,
Your Honor, so that probation
I guess hold
violation.
on one second.
Yeah, we didn't call that case.
Yeah, let's call the district court case too, because we're crossing over here. That's file number 2417615. And that is the district court probation violation file. So Ms. Chady, you're the prosecutor on that file.
Yes,
Okay.
Your Honor, and today is the date and time set for a sentencing on one probation violation, and as the court is aware, there was another active probation violation that was set for a hearing in March that defendant requested an adjournment of. And in terms of that, I believe that speaking with Mr. Vernon, Mr. Law was going to admit to the other probation violation. I think in this case, it's been pretty clear the defendant has just been asking for adjournments. He's clearly shown, even when he is out of jail, that he's not complying with court orders. There's further argument that we have about that sentencing, but I would not agree to an adjournment of the sentencing.
Ms. Coke, as to the adjournment of the felony file.
You know, I had planned to withdraw the offer at the next hearing, which is what I stated on the record in 3-6. But to be fair to Mr. Vernon, he just came on this file. Mr. Germuthi left our defense contract and Mr. Vernon took all of those cases. So because of that change in attorneys and let him catch up on all the files, I would not object for one more adjournment on the felony file.
Okay, all right, so if there's no stipulation to adjourn the probation violation sentencing for today, which there is not, I think given Mr. Law's course of conduct here, the court would not grant an adjournment of the probation violation sentencing. So we would proceed on that. I don't know if you want a chance to talk.
I just wanted to point out, I don't think my client's intention is trying to avoid any of this. He's just trying to make sure that the time he sits in jail, he gets credit for. He's not trying to run away from this. He's already admitted the behavior in the bond violation. So again, we're not suggesting that he's trying to avoid it. Simply trying to make sure that the time that he sits in jail, he gets credit for.
Understood. I think it's a question of whether he should get credit on felony file for violating his probation, the district court file, and I think that's the prosecutor's position. I think that's a valid position. So I think he violated his probation. He needs to serve a penalty for that. I don't think it should ask if any other circumstances rolled into another sentence, given its course of conduct. He will get all the credit he's entitled to under the law based on the statute.
That understanding, Your Honor, it's my understanding that Mr. Law will be entering a plea to the probation violation.
Okay, and then we're going to adjourn the felony.
That's what we would ask the court to do.
So if there is no objection by the people to that, so we'll adjourn the felony file out. Set that for hearing. In terms of the other probation violation. because he pled to one of the violations. Ms. Chady,
So this one would be the request and summons that was filed at the end of February, Your Honor.
February 26th.
Yes.
Okay.
This is what it alleges that he has violated the no contact order while he was incarcerated.
Okay. So,
Correct.
Mr. Law, have you had a chance to talk to Mr. Gordon about this?
I have.
Do you want any more time to do that before we proceed here today?
No, Your Honor.
Okay. You understand that you would have the right to have a hearing as to whether or not you violated your probation?
Yes, Your Honor.
And if you plead guilty to that violation, you're going to give up that right?
Yes.
Is that how you want to proceed?
Yes, Your Honor.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, man. Mr. Law, you understand, is this a non-technical violation? Katie, or Ms. Morgan?
Thought it was alleged as a contact, as a technical violation.
It is a technical?
Yes.
Okay. So is this a first technical violation? So it's maximum of 5 days?
Pulled it up, it said, except for in a domestic violence case, that the 5 days didn't apply, so.
Make sure that we're doing this correctly. And I don't handle district court probation violations very often, so I need a second to check.
Your Honor. We'd ask you to look at section 771.4B subsection 6. You have a copy of that statute here. if you'd like. Point 4B.
$71.
Point 4B subsection 6. You can also read that for the court.
Okay, so he's subject to the standard maximum possible penalty on the underlying charge. Is that correct?
Believe so, and then subsection 6 says that the subsection 1 for the 5 days does not apply to an individual who's on probation for domestic violation,
Okay,
violence violation.
all right, so what all this means, Mr. Law, is regardless of the fact that this is a technical violation, which typically would make a difference in your maximum penalty, because the underlying offense is domestic violence, it does not, and if it's subject by pleading guilty to the violation to the maximum possible penalty on your underlying charge of domestic violence, which is up to 93 days in jail. You understand?
Yes, Your Honor.
And again, you understand that you're giving up the right to have a hearing as to whether or not you did violate your probation.
Yes, Your Honor.
With all of that in mind, what is your plea to that charge today?
Guilty, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything to get you to plead guilty?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you did violate your probation?
Yes, Your Honor.
Back on or about February 26th of 2025, were you on probation in the district court here in Crawford County?
Yes, Your Honor.
Were you aware that one of the conditions of your probation was that you were to not have any contact with Amanda Hall?
Yes.
While you were incarcerated at the Antrim County Jail, did you have a phone call between yourself and her?
Yes, Your Honor.
The court finds that your plea is knowing, voluntary, and accurate, or to satisfy if there's a factual basis to support a finding that you did violate your probation as alleged in the warrant of February 26, 2025, the court will accept the guilty plea. And do you want to proceed on sentencing as to both violations today, Mr. Vernon?
We have a copy of the recommendation, Your Honor, so we're ready to proceed.
Ms. Chady, any objection to that?
No, Your Honor, we did receive a copy of the recommendation. We are ready to proceed. Thank you.
Ms. Chady, do you have any victims that wish to address the court today?
Your Honor, the victim in this case is not present. I was able to speak with her prior to today's hearing. She did ask to orally communicate her comments about the sentencing. They have echoed what she's previously stated, that she would like the defendant to get the help he needs, and she does not believe that a jail sentence is helpful to him. And if you would allow the people to have their comments about the sentencing recommendation now. Today, we're sentencing on 2 probation violations. That recommendation also has the revocation of the deferral. As this court would recall, in November of 2024, Mr. Law was sentenced under the DV deferral statute with 1 year of probation. And as the court has been made aware, ever since that date, there has been continued disregard of the court orders and that deferral probation order by Mr. Law. Every time he has been out of jail, he has found new ways to contact the victim in this case, which the court should view as him not having any regard for these orders and even the safety of the victim. In this case, we think the revocation is appropriate and would ask that you order that as well. Thank you.
Mr. Burke.
Mr. Law is motivated primarily by having contact with his children, not with Ms. Hall. Unfortunately, he can't contact his children without having contact with Ms. Hall. He understands that's a problem. Unfortunately, he doesn't know of any other ways to have contact with his children except through Ms. Hall. So he admittedly made some poor choices. The goal here isn't to, contact Ms. Hall or harass her. But he understands that by trying to contact his children, that is the effect. We would ask the court to keep the deferral in place. We would ask the court to consider a lesser jail sentence than the 30 days. Again, I think as it is a technical violation, something in that 5 days would be appropriate, understanding the statutory construction. Something in that 5 days would be more appropriate. If the victim doesn't want him to go to jail and wants him to get services, it seems to me that supervision pursuant to the deferral is the best way to accomplish those things. If she doesn't want him to go to jail, it seems like she does not feel as though he is a risk to her. And that is the primary component of this sentence. So it seems to me that something less than what is recommended would be appropriate. Ask the court to consider those things.
Mr. Law, you wanted to say something?
No, Your Honor.
Okay, I'm familiar with the facts of your case. It's on the different proceedings that we've had, issues that you've had, while you were on, issues that you've had since you've been under sentence on probation. It's concerning to me that you continue to have contact, even in spite of having more than enough notice that contact isn't appropriate for any reason, including trying to contact your children. And I understand that these circumstances make that difficult. And I understand you wanting to contact your children and having, the right to have some contact with them. But it has to be done in a way that doesn't violate the orders in this case. And you've continually done that. Again, despite having more than enough warning that that's not appropriate. And so that concerns me that you're voluntarily choosing not to follow the orders of the court. I appreciate Ms. Hall's statements through the prosecutor that she doesn't want you to serve jail time. Victims in domestic violence cases often, I think, feel that way for various reasons, other than that you don't pose a danger. And so while I certainly take her views into account, I also have to look at the broader picture here. And in my view, it does, your behavior while on probation does warrant some sanctions. One of those being with withdrawal or revocation of the deferral status. I think given your behavior while on probation, you've demonstrated to the court that we're not somebody who is deserving of to earn the deferral. At least that's for people who spend their time on probation, complying with all the provisions that don't have issues. And again, based on your continued contact in the various ways that you've achieved that contact, I believe that the jail sentence is appropriate, hopefully to reinforce to you that there are violations of the court order by having contact with her with time and justice so that you cannot contact her. And even that hasn't been completely successful. So the court finds that an appropriate sentence is to revoke the 769-4A deferral, to continue you on probation, to sentence you to 30 days in the Crawford County Jail. Ms. Norrigan or Ms. Shady is to be entitled to credit for the probation violation at this time. So 30 days in the Crawford County Jail, credit for 0 days served. You do have the ability to seek an appeal of the sentence. If you wanted to appeal it, you would have to file for that appeal within the next 21 days. If you wanted to do that, Mr. Brenner would be able to help you with that process. And otherwise, we'll proceed, as I indicated, in June with hearing on the felony case. Ms. Coke or Ms. Shady, anything further that we need to address any of these files today?
No, Your Honor.
No, Your Honor.
Thank you.
Oh, nothing else.
Okay, thank you. That's all. Mr. Vernon, do you need a minute with Ms. Hart to?
Yes,
Okay, we'll take a short recess and we'll come back on the record at 2:15.
thank you.
I'll take a look and see it.
I'll put this date at the bottom and I will bill Mr. Vernon's copy. Thank you so much.
Thank you.
Well, it's nice to meet you. Yes.
Yeah.
We're on record as People versus Heather Merchant Hart, file number 255384. Record should reflect Ms. Merchant Hart's present here in the courtroom today. We have counsel for your appearance.
Sierra Coke on behalf of the people.
Adam Byrne on behalf of Ms. Hart.
Okay, this is the date and time set for sentencing in this matter, just so council is aware. I did receive Mr. Vernon for sentencing memorandum. Review that. I also attached to that were 17 letters. I had a chance to review all of those documents prior to the hearing today. Jump into the content. Have you had a chance to go through that before? Talk to Mr. Vernon about that. Mr. Vernon. Well, first of all, Ms. Pope, did you review the sentencing memorandum in terms of the corrections?
I did review it. I did not go over the corrections with the probation staff, but I have reviewed them.
Okay. Do you have any objection to the changes requested by Mr. Vernon?
No.
Okay. So, Mr. Vernon will make the corrections that you outlined in the memo. Are there any other additions, deletions, or corrections?
So just to be fair to everybody, the first one on page 1 of the evaluation and plan under the compass chart we identified is highly probable for substance abuse. We did not actually make a request for a correction there. We would simply ask that it be unlikely, be the appropriate designation there.
My view was I would certainly take into account for evaluations, and I'm sure we'll hear more about that as we go. But the compass test is what it is, right? Mr.
Correct, Judge. It's that based on the assessment she fills out, which also correlates with her charge. So I think a lot of times, anytime there's a charge that involves alcohol or drugs, that's going to trigger that. So that's kind of out of my control. That's just based on her assessment.
Right. So I wasn't going to order a change on that.
Okay.
But certainly acknowledging the evaluation that she did have.
And then I would simply identify, you identified that there were 16 letters. 2 of those are psychiatric or psychological or substance abuse evaluations. So there's a distinction between letters in the community and those letters.
Correct.
So other than that, no, we had no other additions, solutions, or corrections.
Okay. Any challenges to the scoring of the guidelines?
No.
I'm sorry, one year misdemeanor.
Yeah, these are misdemeanors, so there are no guidelines.
Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for Alex?
And I did speak to Sergeant Lohr. He is not present today because he generally doesn't speak. He wanted me to let the court know that this is one of the 5 worst RNOs that he's ever dealt with in his career. During this, when I did this plea offer, I spoke to the doctor who wrote the letters, and the doctor explained that she was on testosterone therapy and people have different levels of testosterone they're comfortable with, and that she was self-medicating with these under his care. I mean, she wasn't doing it on her own, but she was giving herself the testosterone. And I asked him if that would cause aggression, and he said it depends on people on their own, what they have. Like, some people have a baseline different than other people. I did give her a plea offer that allowed her to not have a felony on her record based on all of those things. But I'd asked the court to follow the recommendation because, in this case, she bit the sheriff's office, Sergeant Lohr. She kicked MSP Sergeant Medler. She tried to break the window out of the police vehicle. It almost caused Sergeant Lohr to be pricked with a needle in the hospital because her behavior was so completely out of control towards the phlebotomist. She was very rude to the phlebotomist. Not only was she flailing around and making it extremely difficult and dangerous for everybody, but she was derogatory to her, telling her that she had done nothing with her life. And did she know that she had a master's degree and all kinds of other things that frankly were just really rude to the phlebotomist at the hospital. That's what the officer told me. She repeatedly asked for for Sheriff Swope, saying that he was her get out of free card. That's what the officers also told me. The stop happened at 12:21 p.m. after she had run into the side of a establishment in Roscommon County. She then drove into Crawford County. She was stopped at 12:21 p.m., but the phlebotomist couldn't draw her blood because of her behavior and all the things that happened. until 2:42 in the morning. So it took them 2 hours and 20 minutes to complete the stop. The first officer on the scene, just because she talks about her trauma and all of her flashbacks, was a very small in stature female officer. She was the only one on the scene when the stop happened. She had to call for backup, and obviously other officers responded. But this would have, if she had just responded to Deputy McIsaac politely, given her stuff and acted appropriately, none of this would have happened. She would have been dealing with just a regular high BAC. Her blood alcohol 2.5 hours after the stop was 0.212. The recommendation here is 1 year probation, 30 days in jail with 1 day credit. And I think that jail at some level and some degree is necessary because of the extent of how long this RNO happened. We see RNOs all the time where people get pulled over, they're jerked to the officer, they try to get away, and that's the end of it. That's not what happened. This went on for hours. They couldn't even book her into jail after because of her behavior. So I understand that. I read all of these. She is obviously a good member of the community. I know her and her family. I know Mr. Hart, and I'm sorry to have to be here today, but the facts are what they are, and I'd ask the court to follow the recommendation. Thank you.
So first, I asked the court to not consider the statements that Ms. Koch had just identified as being from other officers that were relayed to a police report and who are not here to testify before this court. The statements made regarding the plea were that she failed to comply with the lawful commands of an officer. So I would ask the court to consider only that information related to the sentencing offense. The statements and the behavior that Ms. Hart demonstrated that day are, as identified in our argument, not something she's proud of. They're not something that she is normally inclined to do, represented by all of the letters of support that you received through the sentencing memorandum. Ms. Hart is a well-respected member of the community. She does a great deal to reach out and help other members of the community. This behavior is completely out of her character. I think that that is further demonstrated by the fact that she was under the care of Dr. Strickler and being administered testosterone as part of a hormone replacement therapy treatment. Dr. Strickler is here and can answer whatever questions the court may have related to that program. We identified in our memo that the process of moderating hormones in any person is a process. It's different for everyone, as Ms. Koch identified, and that because of that, there are often highs and lows in the process. There's high levels, there's low levels, and the doctor has to monitor that and make sure that adjustments are made so that the testosterone levels or other hormone levels are adequate to achieve the appropriate results without being too high. Clearly, in this instance, as they were starting this process, the testosterone levels got too high. As we identified, her testosterone levels were at 796 units. The normal would be for I think it's 53 was the normal for a woman. So we're talking almost 12 times the normal dosage. That taken alone would anticipate some sort of aggressive, even violent outburst when confronted with a new and confusing situation. The reality is that Ms. Hart left the roadway and crashed. Airbags deployed. There was a hole in the front windshield. So a fairly significant crash. The airbags deploying, her hitting her head on either the airbag or something else certainly would have added to that level of confusion and increased her, not only her testosterone levels, but her adrenaline levels as well. So I think all of those things taken into consideration together give us a better context for the situation that Ms. Hart encountered. I'm not saying this to excuse her behavior. She admits that what she did was inappropriate and dangerous for everyone. I bring these to the court's attention because at that point, I'm not sure she had a great deal of control of the situation. I would analogize it to a weightlifter who's had like a roid rage incident. There's too much of a testosterone or another steroid in their system, and essentially they lose control. And I think that that's not a perfect analogy, but I think it's it's essentially what happened here. She had adrenaline rushing through her system. She was confused due to the accident. She had again extremely high levels of testosterone in her level. Those have now been managed. She's working closely with her doctor. Those levels are now down in an appropriate level. So I don't think the court's going to see this type of behavior again. I think this was a one-off. I think that because of the unique circumstances, that the timing of the accident or car crash and the timing of the treatment coincided to result in what we have in front of us, which was a dangerous situation for everyone, certainly. Upon consulting with me, we discussed what best way to address this, and one of the things we decided was to have a substance abuse evaluation done because we wanted to make sure that if there were problems, that we addressed them and got them handled before this court ordered them, or so that we can inform the court of where we were, and if there was a problem, that we could start attending to it. So she had a substance abuse evaluation done through the Grace Center, and she had it done through Begin Again counseling, and both of them came back again as attached to the sentencing memorandum that she does not have a substance abuse problem, but that she has continued to undergo counseling simply for informational purposes so that she can better address those issues. And if something were to come up, she'd have better information and better tools to address those. One thing I did not address is, it was addressed by one of the assessments, and that Ms. Hart has post-traumatic stress disorder, and that's identified, appears as chronic. I'm not 100% sure she knew that she actually had post-traumatic stress at the time this happened. I don't think it had been previously diagnosed, but the reality is that when she gets into a stressful situation, as most people with post-traumatic stress disorder do, they react in a manner that is inconsistent with community standards. It's not surprising, considering all of these things that she has going on, that she acted in a manner that was inconsistent with community standards. So I just bring all of these things to the attention of the court because I think it's important that you have context as to what circumstances you have to deal with, the likelihood of reoccurrence, and the appropriateness of services to be provided. I think that Ms. Hart presents in front of you as somebody who's wholly unlikely to have something like this happen again. The level of care and attention that she has paid during this process to making sure she has done everything she can to address these issues and make sure that her behavior is appropriate and that any other circumstances like the post-traumatic stress are properly addressed so that she does not find herself in a situation like this again. She has, again, I should tell you that Ms. Hart does wish to have the court hear from her, but that she is uncomfortable speaking and very nervous and uncomfortable in the situation. So she has drafted a letter that we will ask the court to read. We would ask the court not to include that as part of the PSI, but simply as her statement. It includes some personal information that she doesn't want part of the public record. So she would ask that you simply read that statement. Ms. Koch has been provided a copy of that statement as well. But we wanted to make sure that you heard from her in a manner that she felt most comfortable providing you all of the information she felt you needed. Other than that, Your Honor, we are asking the court to consider, we have had contact with the Roscommon County Sheriff's Department, and they have a tether program that she would be eligible for if the court were willing to do that. We could get her set up on that tether program, which would monitor her whereabouts at all times. And then, again, obviously, if there was a problem, we would be able to, they would be able to report that back to this court. And I think that's the type, the level of supervision that is, and the penalty here that is needed. I don't think the jail will do any good for Ms. Hart. She's fully aware of the situation and the harm that she has caused, and the level of sincerity and remorse is, I think, patently obvious from having met with her and discussed these matters with her on a regular basis. So I don't know that a great deal of punishment will do anything more than she's already done to herself. So I would ask the court to consider either holding the jail in abeyance and monitoring her through the term of probation, or allowing her to participate in the tether program. If the court does authorize the tether program, we would ask for a couple of days to get that set up with Roscommon. They know that we're making this request. I just want to make sure that we have sufficient time to get her set up. And I don't know if we can do that before the end of the day today. So we would ask the court to hold the jail in abeyance and or do a tether program through Roscommon County. And if I may present the court with Ms. Hart's letter.
Yes.
Did the court want to look into that, Mr. Cook?
I do have a question for Dr. Strickler. Doctor, would mind coming forward? Just to the podium there, and if you could just tell me your
Strickler, MD, allopathic physician.
Okay, my question, because I read through the reports, is this testosterone level, which Mr. Vernon indicated, normal therapeutic level is whatever 53. I'm not sure what the measurement is.
Yeah.
And hers 700s somewhere.
Correct.
So is that, can somebody's levels get that high from taking it as directed?
If they can, everyone has a different absorption rate. We had actually started her on a topical preparation to begin with, and she was not as compliant with that because of it being messy and sticky. So we had changed her to an injection in August, and typically we'll follow up with labs about 3 to 4 months later, and the incident occurred before we had a chance to follow up with the labs. Now, while her total testosterone was in the 700 range, her free or active testosterone was about 2.5 times normal. So the 700 was not as egregious as it sounds to be.
Because that just seemed like such a wildly disparate number that.
It is.
But you're saying that she wasn't even taking it, it was being administered.
No, she was self-injecting.
Oh, okay.
But she did bring her bottle in for me to look at it after this occurred, and there was an appropriate amount left.
Okay. All right. Does that substance, testosterone, does that have any effect on your blood alcohol levels?
It should not.
Okay. Thank you.
Thank you, Your Honor.
This letter is lengthy, so I'm going to take a short recess because I can read it.
Thank you.
Okay, we're back on the record. And for the record, sorry, I got a chance to review your letter. I appreciate your statements in there and the sentiment that was expressed. So for the record, I had a chance to review the pre-sentence report, so I'm familiar with facts, what bring you before the court here today. Based on the information in that report, I'm also familiar with your background and your circumstances generally. In terms of the statements that the court considers, this is a sentencing hearing. It's not an evidentiary hearing. The court can consider information that might not meet the standard under the rules of evidence, like statements relayed through the prosecutor. However, I'm considering lots of statements on your behalf that wouldn't be admissible either for people who aren't here, and outside information. So the court's considering all the information before it, and I think rightly so. I read through those letters very carefully. There were a lot submitted on your behalf. Certainly you have a lot of community support, and I don't always see that for people that are in front of me. And so what that tells me is that generally you've led a pretty successful life, one that has been characterized by a lot of good, both professionally and personally through the community. And so I'm satisfied that this is not your typical behavior. I don't think those people would be writing letters on your behalf, or you would have achieved the things that you've achieved in your life generally if this was a kind of your standard practice. So I'm willing to accept that this was an incident that was outside of your normal character. I'm also willing to accept that some of the circumstances may have influenced your behavior, not only the treatments that you were undergoing, but the circumstances of the accident. Having airbags go off, I think is a pretty disorienting thing. It's never happened to me, but I understand it's pretty disorienting. And so I can accept that a certain amount of your behavior throughout this incident was attributable to those kind of factors. That absent that, this might have gone differently. On the other hand, I have to look at the other side of what happened here, which is a lot of bad decisions on your part right from the beginning. It sounds like based on your letter and the other information that I read that you were having some health issues, yet you still chose to consume alcohol, which probably was not recommended for you. And I'm sure some, if not many of the medications you were taking, probably advised against using alcohol while you were on them. And that's a choice that you made. Despite that, despite your health problems, you chose to do that rather than just go and not consuming alcohol. Your blood alcohol level of 0.21, as Ms. Koch indicated, well after you indicate that you stopped drinking, doesn't make sense to me. The amount of alcohol that you say that you consume does not match up with that blood alcohol level. Even not having eaten, even at a reduced weight due to your health conditions and all those other factors, it just doesn't make sense to me based on what I typically see in terms of the number of drinks consumed over the period of time in which they were consumed and your blood alcohol level. If you really only had 5.5 or 6 beers over that period of time, it just doesn't make sense to me from a common sense standpoint. And admittedly, I'm not a doctor, but for your blood alcohol to still be at 0.21 indicates to me that there was more alcohol consumed than what you're claiming. You made the decision after consuming alcohol to drive. You had one impact and then continued driving and went into the ditch. So that's another bad decision. After consuming the alcohol, you made the choice to go out and drive. And at that kind of blood alcohol level, it's not surprising to me that you got into an accident, because that's severely intoxicated, well over 2 times, almost 3 times the legal limit. And I think you're lucky that no one else was injured during this encounter, because I can tell you, if you had run into someone or hurt someone who was innocently on the road that night, they or their family would not care about your testosterone therapy, about all these other issues. They care about their loved one that you could have hurt. And so you put yourself and everyone else on the road to danger that night. Your interactions with the officers, again, I can accept that circumstances could have led to some of that behavior. But from what I read in the report, and I didn't watch the video, and maybe for you, it's a good thing that I haven't, because I suspect that your behavior, based on your own description, in your letter, was pretty out of control. And while again, I think some of those factors could have contributed to some level of confusion and inappropriate behavior, I think there are a lot of people that undergo these kind of treatments or in similar circumstances who don't act the way that you did towards those officers. And they're doing their job. They're trying to keep you and everybody else safe. You put all of them at risk by your behavior. Even the hospital staff people who absolutely did not deserve to be treated that way. Officers didn't deserve that either. But certainly hospital staff didn't deserve to be treated the way that they were treated. And I don't think that your medical conditions and other conditions are an excuse for treating people that way. And I do think that in terms of an appropriate sentence, I do take into account the mitigating factors that I've talked about, that I do think should not result in the highest possible sentence in this case, because I do think your community record, your professional, your personal record, your lack of prior history, and your medical complications all deserve and warrant consideration. But I'm not just looking at this from your perspective. I'm looking at this from the perspective of the entire community, from the police officers, from everybody who was involved in this incident. And from that perspective, there does need to be a deterrent effect to this sentence so that people understand that you can't put yourself in a position where you lose control and lose the ability to conduct yourself in just even a reasonable manner, which I find did not occur in this case. So for all those reasons, I do think, number one, that probation is appropriate. I think 1 year is an adequate period of probation. That would provide a degree of supervision, although I tend to agree, I don't think you're the type of person who's going to need that. You would be eligible for early release probation. I suspect that it's likely to be the case for you, because I don't see this as being something that you're going to repeat or engage in again. However, because of the degree of your behavior, the egregiousness, the danger that you presented to the community, to the arresting officers, to everybody that you dealt with throughout the course of this incident, again, I think there does need to be a punishment aspect of this and a deterrence aspect to this. And I think 30 days is a reasonable sentence. I think it accounts for your conduct in this case, provides a degree of punishment, a degree of deterrence. It also recognizes, again, all those mitigating factors that I mentioned. So the court is going to place you on probation for a period of 1 year and adopt as the conditions of the probation all the terms and conditions listed in that report. The court is going to order that you serve 30 days in the Crawford County Jail with credit for 1 day served. The court is going to order an OWI reimbursement pursuant to statute of $280.86. That's payable to the Crawford County Clerk to be dispersed to the Crawford County Sheriff's Department. Crime victims assessment of $130, court costs of $325, state costs of $100, supervision fee of $30 per month while you're on probation. This is a misdemeanor offense, so there are no written appellate rights. You do have the ability to seek an appeal of this sentence. If you want to do that, you would need to file for that appeal within the next 21 days. About that or pursue that.
No, thank you, Your Honor.
I can pay those costs and fines today, Your Honor.
Mr. Vernon, I'm going to return this letter to you.
Thank you.
I
I appreciate that.
The
Judge Taylor didn't pay her fines and costs. Her bond has already been applied, so the balance that is on that case is what's issued.
I'm sorry, what did you say was due?
The balance, I applied her bond,
Well, yeah, what was the bond?
150, so balance is 688.86.
Thank you.
Thank you. Next matter, Mr. Trish here.
Mr. Trish is here. I keep seeing him poke through the window.
I asked Mr. Schwartz just about,
Mr. Trish, you have Ms. Williams.
Come on.
Since file number 25538 5381.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Trish Green on behalf of Ms. Williams.
All right, this is the date and time set for sentencing in this matter. Ms. Williams, have you had a chance to go through the pre-sentence report and talk to Mr. Church about that?
Yes.
Mr. Church, are there any additional stations or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Coe, do people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring?
No, I believe it's scored properly.
Anything on behalf of the people for allocation?
I really struggled with what the proper recommendation is for this. Ms. Williams is 29. She has one prior misdemeanor and one prior felony. It's been a very long time since she's been in trouble. She did have 2 back-to-back methamphetamine cases. And I am familiar with the facts of her first methamphetamine case, which, as I said, was almost a decade ago. She is a single mom to a little girl. I know her whole family. Her father is in prison. Her mom has left the state. She is here taking care of this child on her own. And frankly, I have no idea how she got herself back into the situation. She was doing very well, but she had a cousin that got out of jail who I have to prosecute pretty frequently. And Taylor is a follower. She follows people right down the rabbit hole of bad decisions. So as much as I wanted to be surprised that I saw her, I guess in some ways I wasn't, because as soon as her cousin got out of prison, who's now back in prison, Taylor went right down that hole. And that's the police report's all about, the cousin and how they were looking for the cousin and found Taylor, and she had all the methamphetamine on her. The guidelines are 0 to 17. We're dealing with a high severity felony. I do think, 10 or 30 days of jail might be appropriate, given that, this is 2 methamphetamine cases, been pled down to 1. I'd really like to see her do well in life. I'd really like to see her stay away from the people that lead her down this rabbit hole every time, because if we don't, ultimately she's just going to end up, with longer and longer jail sentences and eventually a prison sentence. So I do think 10 or 30 days might be appropriate. I defer to the court on that. Thank you.
Mr. Church.
Thank you, Your Honor. So I think a lot of what the prosecutor said is well put. I would indicate, one, I don't think this person's actually a biological relation to her. I think it's just a friend, not a family member. But I think what is important to look at here when looking at a sentence is we did have nearly a decade of success. So I think to categorize that she's a follower, I think that's probably not accurate. We had a good decade of good, clean sobriety where she was doing the things that we'd expect a productive member of society to do. Yes, she had a relapse. Since the relapse, she's got involved with counseling. Her and I talked a little bit about her counseling today. And she talked about one of the things they're looking at is identifying the triggers, right? And when they identify a trigger, okay, when that happens, what are we going to do to react to, right? What are we going to do so we don't go down the same patterns that we're going down? She has a wonderful rapport with her therapist, who seems to be very committed to the process with her. She's indicated to me the therapist is available for her even sort of at non-scheduled times. She can reach out to her and they will get back with her. So I would suggest to the court, given the relative lack of history, the significant period of success that we had, that imposing upfront jail, I think, would be a mistake here. I think maybe holding a significant amount of jail in abeyance is a better route to go. She's actively engaged in counseling and doing really, really well. I think giving her an opportunity to continue that would be the right approach.
Anything you wanted to say?
Just want to say I'm sorry, and I know what I did was wrong. Trying to be better, and counseling has helped me a lot, so.
I do just want to clear up factual for the PSI, because it does indicate when you said relationship, are you talking about Miss Nish?
Yeah, she's not.
She's not your cousin. Okay. So can we make that correction?
Yes.
Because the PSI needs to be accurate, and it says that your cousin here, but you're not. So I did read through the report, and I saw where you did have a significant period where you didn't have any contacts with law enforcement. And so it certainly is a basis for the court to find that this is a relapse backslide that you can move on from and have a significant period of sobriety going forward. And so I think the sentence needs to be tailored towards that, towards rehabilitation. And I agree with Mr. Trush that absent your clients with probation, then it's time to penalty. And so I think it's appropriate to give you that opportunity up front. So I am going to post some jail, but I'm going to hold it in advance. If you comply with the probation, you won't ever have to serve that time. But if you don't, what you'll be telling me is that you're not where you need to be, and there needs to be additional motivation. So I'm going to adopt the recommendation. The court is going to sentence you to probation for a period of 2 years. If you do well on probation, you have the ability to be released early, and only do like up to half of that time. Do well on probation. So hopefully that's another motivator for you to comply. The court's going to adopt as the conditions of probation all the terms and conditions listed in the report. The court is going to impose 3 months in the Crawford County Jail with credit for 3 days served. The court's going to hold that time in advance to be used at the discretion of the court. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, and a supervision fee of $30 per month while you're on probation. You have the ability to seek an appeal of the sentence. Mr. Church provide those public rights. Has Ms. Williams received her appellate rights?
She has.
Okay.
You're gonna need my. May I approach?
Yes. Next matter is People versus Elizabeth Cooper, file number 255347.
Yuriko can be up the people.
Thank you, Your Honor. Richard Church, on behalf of Mr.
The record should reflect Mr. Cooper's present here in the courtroom. This is the date and time set for sentencing in this matter. Ms. Cooper, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, sir.
Mr. Trush, are there any additions, deletions, or corrections to that report?
There is one correction, Your Honor, and that's on CFJ 284, page 9 in the subsection marriage. And that lists Danielle Johnson as her significant other. I do believe that they had a dating relationship when they were teenagers, but they have not been together for some time.
Okay, what would you like that?
I would just ask to strike it. They're not in a relationship anymore.
You have any objection to that change, Ms. Coe?
No.
Um, Any other changes? Mr. Church?
No, Your Honor.
Mr. McDowell, we're just discussing the report here. Mr. Church has to have the marriage section. Information deleted. Ms. Coe didn't have an objection. Apparently that was a dating relationship in high school.
Oh, okay, gotcha. Yep, will do.
You said no other changes, Mr. Church.
Correct.
Any challenges to the scoring?
No, Your Honor.
Ms. Coe, any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for?
This situation was really kind of ridiculous with her faking seizures. The guidelines for the 3 charges are 0 to 17, 2 to 17, and 5 to 23. The recommendation is 5 months in jail with 6 days credit. That being the low end of the highest set of guidelines. I don't know why she went down this road, and she had just, responded in an appropriate manner. She frankly would not be looking at anywhere near this recommendation. She doesn't have any felonies, and she only has 4 prior misdemeanors. I think if she continues down this path, we're going to be seeing a lot of her. There's some credit to be given for the fact that she took the plea. It started off with, he said it was all her, she said it was all his, and they both said they didn't know anything about it. But the fact that she's taken some accountability for it goes in her favor. I'd ask the court to follow the recommendation. Thank you.
Thank you, Mr. Church.
Thank you, Your Honor. This is one of the more difficult cases on my docket right now. And I identified that for the court because Ms. Hooper has significant mental health issues. I have been working with her, I've been working with Elizabeth for a long time. As a prosecutor in Otsego County, I dealt with her in her juvenile years. Since joining the defense bar, I've been working with her for a little over a year now in regards to this matter and the district court matter as well. There's significant progress here. She is working with a neurologist. She is making progress on addressing some of her issues. Not going to say it's perfect because it isn't. But I have seen significant progress in the last year. The basis for recommending just a straight jail sentence and no supervision seems to rely heavily on the fact that she was unsuccessfully discharged from her district court probationary term. I take a little bit of umbrage with that. Outside of that unsuccessful discharge, I think she has successfully completed probation every other time she's been placed on probation, with the exception of a consent calendar, I think when she was 17. So I think she is actually a good candidate for probation. And frankly, I think probation is a good thing for her because it helps to keep her grounded. Having been involved in the violation case in district court, frankly, I don't know that they would have discharged her from probation in district court if they had been aware that she was not going to get probation here. I think they assumed that she would be having supervision to the circuit court, which is, I think, part of the driving factor of them discharging there as opposed to continuing. The circumstances here, Ms. Hooper, because of some of her neurological disorders, she is, to borrow the prosecutor's term, I think, a follower. This is a circumstance where I think she got herself involved with someone who did not have good intentions, didn't have good intentions in terms of what to do that night or good intentions for Elizabeth, frankly. And she got led down a bad path. She is someone I think needs to be extra vigilant about who she surrounds herself with because she is vulnerable. She is prone to being taken advantage of. I would suggest to the court that I think this is the rare circumstance, given that there are 0 prior felonies, only prior misdemeanors, given her unique mental health situation and her vulnerability. I think this is a circumstance where a downward deviation may be appropriate. And I would suggest to the court that a probationary term is likely appropriate. I think that's both in her best interest and the community's. Thank you.
Great, thank you. Or anything that you wanted to say?
Yes, sir.
want to say hello. My name is Elizabeth Hooper, and I am and have been trying to work with CMH as much as I can. I understand I have messed up very bad, and I don't understand why I put myself in a spot like that. But I have, and I understand it was wrong, and I have been feeling very bad since it happened. I am a bit of an unstable person. I have been fighting with epilepsy for years with not much of a good outcome. I have short and long-term memory loss, and that has came with a lot of issues that I need and have been receiving help for on the outside. And I am worried that if I go to jail for a long time and I can't receive my help for these medical issues, and I can't and I can't get to for the appointments, like the surgeries I have set up as well, that I'll be very hard. I have waited for over 6 months for the dentist to get my molars out, and I have back surgery on my spine to be able to talk to the brain doctors. It feels like my meds need adjusted, and I truly appreciate help on the outside, and I do not want to have worse memory loss from not being able to keep my brain busy. I already am unsocial, and it has took a lot, and I have to reteach myself a lot, and I truly am disappointed in myself. I have a lot of regret, and I do not want to have a seizure in there and my meds be all messed up and not receive care, have a stroke or a heart attack, and not receive help because of a mistake I should not have ever put myself in, and it should not ever have happened. I do not understand or comprehend what I'm doing sometimes, and if I could change that, I would. Head trauma is really hard part of my brain being messed up. It's the left and the right side of my brain that's messed up, and that's how you think, walk, and talk, and respond, motor, seeing, hearing, and that comes with a lot of diagnosed problems. That part of the brain controls learning and memory, and I've had a very hard past 5-6 years, and I may need brain surgery because I have very serious and very bad seizures, and that will be very hard in jail. And I would just like you to know, sir, that accident might have happened, and I would just like you to know, and if you would like me to bring any of them paperwork in from my neurologist, the part of my brain that's messed up, it kind of like, just like when one of the last times I went down there, it messes with that part of the brain and it makes it spaz out even when I'm not having a epileptic seizure to where I'm breaking bones and breaking my body. My brain still gets lost there, and sometimes I can go out so I can be on my 2 feet and I'm walking and I don't understand what I'm saying, or I don't understand how I'm doing. Just like in the district court, before this, we had a case with disorderly conduct, and what happened was I was at the hospital and I was asking for help, and I've been all over these hospitals in northern Michigan, and it upset them and they didn't want to deal with me, so they had put me outside the hospital and they called the cops. I've been having a very hard time receiving help for my brain being messed up on the left and the right side, and having epilepsy and having a bunch of mental disorders that come with that. And I was at my grandma's before I came over here, and I wasn't able to get the help for any of them things because my grandma is elder and she cannot drive or help with any of that. I came over to my dad's and I had just started receiving this help. So I'd like you to know, since 2020, this is the first time that I'm able to talk and move around. When I was at my grandma's, it was about every 2 weeks that I was ending up back in the hospital over in Grayling and over in Kalkaska and getting transferred to Traverse City and all over Michigan. I have a lot of important things I'm trying to keep track of, and I'm trying to keep growing. And if I could just ask you to be a bit understanding and just understand I'm not like that, and I have removed everyone like that from my life. And if I do go in, is there any way I can still get help for these things? Like, I have an appointment for oral surgery set up, and the appointment for the consultation oral surgery I have for my spine. I've broken my spine in 6 spots having seizures, and I have a neurosurgery appointment set up to have a consultation on my back. I work with the psychs. I see them every 2 weeks to once a month, and I need physical therapy in areas like that. My epilepsy doctor, I see him in June, and I'm supposed to see my family doctor twice a month. And with back surgery coming on, I'm supposed to start a little bit more to kind of keep things going in track. I've been trying really hard, and this is the first year in probably 6 or 7 years I've been able to get up and on my feet. If you would ask Mr. Trush, like from 6 months ago, every time he would call me, we were just going around and around, and he wasn't really understanding what I was saying without medication help. And we were having a very hard last court date, and them things should have been taken in a different manner. And I understand the way that the law looks at me because I've had a very hard time in the hospitals. And when I'm going through things like that, I would like you to know that I'm not faking it. I'm not trying to make it look like that to other people in the world. And I understand being in and out of the hospitals for over 6 years, the officers are going to listen to somebody like them. And my neurologist would be able to explain that a little bit better. I went down and I spent like 2 weeks down there with a bunch of things hooked up to my head. And that is what started bringing me a little bit of life back. And I'm just trying to stay on that path of doing better. And I understand that I did wrong, and I've been trying very hard to keep myself away from that and to make sure that I have a counselor, I have a psychiatrist. I let 2 ladies from CMH, they come over to my house twice a month and they sit down and make sure we're working towards better things, like focusing if I can go a whole year to get my license, and focusing on getting my own place and making sure that I have a life alert button or something with me too if anything happens, and helping me grow in life, helping me make big changes. And thank you, sir.
All right, I did review the report, so familiar with all the information in there. Talks about what happened during the course of this incident, and then also about your background. So take all that into account along with what the lawyers had to say, and of course what you had to say here today. And I think, you know, the district court probation obviously didn't go well, but I see a lot of people who still have probation recommended who've had way more failures than you have. And so I am going to depart from the recommendation in that I do think probation is appropriate. I think some supervision would be helpful for you. And if it's not successful, it's not successful. But I think at your age, given your history, lack of prior felony record, and really, you know, I think been on probation 3 times with 1 failure. I'm not ready to say that I don't think it could be beneficial.
Yes.
And it'll provide a degree of supervision, and then maybe some of those things can be followed up in terms of counseling and so forth, to the extent that you're not getting what you need now. At least have a better shot of that than just a straight jail.
Yes, sir.
I do also think that there needs to be some punishment for your conduct in this case. You know, given all your issues, which you're fully aware of, you need to stay away from these kind of substances and people that are dealing with it, because that isn't going to help you at all. That's only going to make things worse. So if you really want to work on getting better, if you really want to work on having a more productive life, dealing with the conditions that you have, which I believe are legitimate conditions, you need to stay away from this stuff, because it's, number one, it's going to make your health and your mental state worse. It's not going to help it. Even if you feel better temporarily, long term, it's only going to make all of that worse. And at some point, make it impossible to get better again.
Yes, sir.
And it's going to wind you up in jail more often. That's not going to help you either in terms of dealing with those things. So if you're really serious about that, if you really want to deal with it, you need to stay away from the people that are involved in it. You need to stay away from it yourself.
Yes, sir.
And so I think, again, probation's appropriate. I think a jail sentence at the low end of the guidelines provide a degree of punishment, hopefully motivation to you to not do this anymore, to stick with your probation, stick with your treatment, stick with your counseling. So as to all 3 counts, the court is going to put you on probation for a period of 18 months. The court's going to adopt as the conditions of your probation all the terms and conditions that are standard. The court is going to order that you serve 3 months in the Crawford County Jail with credit for 6 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $204 state cost. You have the ability to, and I'm sorry, and a supervision fee of $30 per month while you're on probation. You do have the ability to seek an appeal of this sentence, and Mr. True should provide those appellate rights to this.
3 months and a year and a half probation. Yes, sir.
Conditions.
No, Judge, I think I know what to do and I'll get it.
Do you want to meet with the super right now? Or,
No, I'll come see you at jail.
okay.
Let's grab them out, send them back, these guys. send them back here.
Yep.
Oh, sorry.
I do have the executed advice with rights. May I approach?
Yes. Sure, you're representing Mr. Duval.
I am.
Is he lodged or?
Duval's right there.
People versus Larry Duval, case number 25. This is District Court case number 2517825-FY-1. I'm presiding over this case by assignment. The record should reflect Mr. Duval present here in the courtroom. If I could have counsel for your purposes.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church appearing on behalf of Mr. Duval.
All right, I believe we're set for a pretrial conference today. Is that correct?
Yes, Your Honor, we're set for a probable cause conference today. I've had an opportunity to discuss this with the prosecutor as well as Mr. Duval. We're not going to be needing a preliminary exam on this. I don't think we have a resolution of it quite yet, but we're in negotiations and we'd be prepared to waive the prelim today.
We have no objection to that. I have just tendered the offer to Mr. Trush today, as well as some evidence that I'd be waiting on. I have the information, witness and exhibits, and demand for disclosure for the court and defense counsel.
In terms of circuit court arraignment, Mr. Trush.
Thank you, Your Honor. I'm in receipt of the information. The scene of the prosecutor just identified the information, witness and exhibit list and disclosure demand. We would waive a formal reading of the information and we would continue to stand mute for the circuit court.
The court will enter a not guilty plea on behalf of Mr. Duval with regard to the allegations of the information. The court will set this for a felony status conference at its next available date in circuit court. We'll provide notice of the date and time of that hearing to counsel and to Mr. Duval as well. So is there any objection to bond continuing for Mr. Duval?
No.
Court will order that bond be continued pursuant to all the current conditions. Mr. Trush, anything else that we need to address?
Yes, I think the address on the information isn't correct.
Okay.
And I just want to make sure the court has a good address to communicate with them.
So not the Staley Lake.
It is the State of Lake, sir. I bought my father's house next to me years ago. It's 4726.
You should, Mr. Corey, you can write on that.
Okay. Ms. Coke, anything further from your side?
No, thank you.
Great. Mr. Duval, just make sure that you stay in touch with Mr. Trush prior to that next hearing, okay?
Yes, sir. Thank you.
Take care.
People versus William Butts, file number 204727 214739.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church appearing on behalf of Mr. Butts.
Like Mr. Butts is present here in the courtroom today. This is the date and time set for a sentencing hearing on alleged probation violations. Mr. Butts, did you have a chance to go through the violation report with Mr. Trush? Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Ms. Pope, if people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, honestly, this case has been going on just way too long. We've been here too many times. The recommendation is 12 months in jail with 122 days credit on one and 51 days on the other with unsuccessful discharge. I think that's appropriate given the nature of the violations and the background of Mr. Butts. Thank you.
Thank you, Mr. Trush.
Thank you, Your Honor. Not a lot that I'm going to add here. The court presided over the sentencing on the Otsego County matter this morning. I understand the prosecutor's statement that we've been here a lot of times on this. Frankly, we have maintained from the beginning that in regards to the home invasion case that was charged in Otsego County, it was overcharged. We maintained that he never entered that building at all, and that ultimately we would get to the correct resolution, and we did. So I certainly understand that we've been here many times on this, but frankly, I think it was the result of proper discipline to get to the correct resolution in terms of the underlying matter. With that in mind, the recommendation would seem appropriate given the circumstances and where the underlying guidelines on the offenses are. I would suggest to the court this morning, the court sort of declined to, in the Otsego matter, make a statement one way or the other on potential work camp eligibility. I'd ask the court to consider that. If the court is inclined to look at that, we would at least attempt to make arrangements for him to serve the sentence in Otsego so he may be able to maintain his employment.
Thank you, Mr. Button.
I would just like to move forward. I appreciate you letting me hit the car. Yeah, I'm no grateful. Like, you saved the day. I was crying coming in. Usually don't do that. Sorry. I just want to get this over, move forward with what I'm doing.
All right, we've already talked today, obviously, this morning. And the probation in these two files didn't go as sure as you hoped, certainly not as the court hoped. So I think what we're left with now is imposing a penalty. I do think it's appropriate to discharge you unsuccessfully from the probation at this point. There's anything that came from it. And certainly your conduct in Otsego County warranted the violation here, and it warrants additional penalties here. In terms of the work camp, your sentence in Otsego County is 93 days. So I wouldn't consider that until you have served at least 9 months of the sentence here in Crawford County. And I'm in order that they be served concurrently, so at the same time. So I don't know that that's even a workable solution given the circumstances here, because your sentence in Otsego would be up before your sentence would be here. So there wouldn't be any reason for you to go to Otsego. And I do think the recommendation is appropriate here, given your performance while on probation, given the underlying conduct that the violation is based on, and given your sentence in Otsego County. So as to both files, the court is going to sentence you to 12 months in the Crawford County Jail. As to file number 4727, that would be with 122 days of credit. As to file number 4739, 51 days of credit. The court is going to order that you be discharged from both unsuccessfully, or will preserve any outstanding fines and costs. You do have the ability to seek an appeal of the sentence, and Mr. Church and Mr. Butts have now received those rights. For the record, the sentence in this case to be served concurrently to Is that single purpose? You are remanded to the custody of the county at this time, Mr. Buck. That concludes the court's afternoon docket.